Section 115, Estoppel. Estoppel is the principle of a law by which a person is held bound by the representation made by him or arising out of his conduct. The term estoppel is derived from the maxim elegans contraria non est audendus, which implies a person alleging contradictory fact should not be heard, and is the specie of a presumption juris et de jure, wherein the fact presumed is taken to be true against the party stating the same. The principle of estoppel was established in the case of Picard versus Sears, wherein a person by his words or conduct induces another person to believe a fact and subsequently acts according to the belief or to alter his previous position. The accused is barred from latter changing his position. Estoppel is disability whereby a party is precluded from alleging or proving a legal proceeding that a fact is otherwise than it has been made to appear by the matter of giving rise to that disability. The principle says that a man cannot approbate and reprobate, or that a man cannot blow hot and cold at the same time, or that a man shall not be allowed to say one thing at a time and different thing at other time. It must be noted that estoppel is only a rule of civil action and has not and has no or limited application in a criminal proceedings. Estoppel is dealt with in section 105 to 117 of Evidence Act, while section 115 contains the general principle of estoppel by conduct, and section 106 and 117 are instances of estoppel of contract. However, there are other recognized instances of estoppel: the Indian Contract Act, section 234, Specific Relief Act, section 18, Transfer of Property Act, section 41 and 43. Estoppel which are not proved by the Evidence Act may be termed as an equitable estoppel. Under section 116, estoppel of tenant and licensee of a person in possession. This section enumerates the principle of estoppel, which is merely an extension of the principle that no person is allowed to approbate and reprobate at the same time. The section deals with estoppel of a tenant and a license of the person in possession. It is not exhaustive as containing all kind of estoppel which may arise between landlord and tenant. It postulates that there is a tenancy still continuing and that it had its beginning at a given date from the given landlord, and provides that neither a tenant nor one claiming through a tenant shall be heard to deny that the particular landlord had at that date a title to the property, and there is no exception even for the case where the lease itself discloses the defect of a title. In the ordinary case of a lease intended as a present demise, the section applies against the lessee and assignee of the term and sublessee of a licensee. Even before the Act came into force, the Bombay High Court recognized an estoppel of this kind. After the Act came into force, the Privy Council in Kumar Rajkrishna Prasad versus Barboni Coal Concern Limited declares that the section does not deal with all kinds of estoppel which might arise between the landlord and tenant. The estoppel under the section is wide enough to cover all the cases of a grantee who occupies and enjoys under grant disputing the grantor's title. Even a mere attornment creates an estoppel against the tenant, but the estoppel between the tenant and the landlord which fall outside the scope of the section. Such an estoppel does not prevent the tenant from showing that he attorned in ignorance of the fact that the landlord had no title. The test for the purpose of this section is whether the attornment creates a new tenancy. This happens in Adhinath Ghatak versus Krishna, where a attornment was under the threat of eviction by the title paramount and a new jural relationship of a landlord and tenant was created. The estoppel thereafter arises against the attornment landlord. Estoppel of acceptor of a bill of exchange, bailer or a licensee, dealt with in section 117. This section deals with the further instances of estoppel by agreement. Section 116 and 117 are, however, not exhaustive of the doctrine of estoppel by agreement. Agents for the instances are not ordinarily permitted to set up the adverse title of a third person, defeat the right of their principal. Under this section, an acceptor of a bill of exchange cannot deny that the drawer had authority to draw such a bill or endorse it, but he may deny that the bill was really drawn by the person by whom it purports to have been drawn. A bailee or a licensee cannot deny that his bailer or a licenser had, at the commencement of the bailment or the license, authority to make the bailment or grant the license. But a bailee, if he delivers a good to the goods bell to a third person, may prove that such person had a right to them as against the bailer. Estoppel in the case of negotiable instrument are instances of estoppel by agreement or a contract. No person can claim a title to negotiable instrument through a forged endorsement. Such endorsement is nullity and must be taken as if no such endorsement was on the instrument. The bailee and the licensee are placed in the same position as the tenant in the preceding section. The bailee is protected by the bailer's title. The bailee is protected by the bailer's title so long as any better title is not advanced. A bailee entrusted with the case of goods is stopped from claiming that the bailer had no title at the time of the bailment. He cannot set up the title of a third person, but the bailee has no better title than the bailer, and consequently, if a person entitled as against the bailer claims the good, bailee has no defense against him. As between landlord and tenant, so between the licensor and licensee, the former's right cannot be questioned by the latter. A licensee cannot be permitted to deny that his licensor had, at the time when the license commends authority to grant such a license, the license of a trademark cannot put up an end to the relation of a licensor and licensee by repudiating the contract in as much as the concurrence of the other party is essential. Under section 118, who may testify? Under this section, all persons are competent to testify unless they are in an opinion of the court, unable to understand the question put to them or to give a rational answer to those questions owing to tender years, extreme old age, disease of mind or a body, or any other such case. Even a lunatic, if he is capable of understanding the question put to him and giving rational answer, is a competent witness. This section does no more than enunciate the English rule with regard to competency of the parties as a witness without in any way making admissible all the evidence which might be given by them. In this connection, the provision of section 112 must not be overlooked. It has been held that an omission to administer an oath under the Oaths Act 1969 does not affect the admissibility of evidence unless the judge considers the witness to be otherwise competent. In a murder trial, the child witnesses who below the age of 12 years in age clearly depose in terms of the prosecution case, his evidence was found reliable and corroborated with the evidence of other witnesses. The session court was satisfied that he was giving the truthful evidence. Mere absence of oath alone will not make his evidence disbelievable. Once the child witness is found competent, his inability to take or understand oath or omission in administering it neither invalidate the proceedings nor render his evidence inadmissible. The testimony of a child witness must find adequate corroboration before it is relied on. However, it is more rule of practical wisdom than a law. It cannot be held that the evidence of a child witness is a child. His evidence shall be rejected, even if it is found reliable. The law is that evidence of a child witness must be evaluated more carefully and with greater circumspection because a child is susceptible to be swayed by what others tell him, and thus a child witness is an easy prey for tutoring. Under section 119, witness unable to communicate verbally. When a deaf and mute is a witness, the court will ascertain before he is examined that he possesses the requisite amount of intelligence and that he understands the nature of an oath. A deaf and mute's evidence may be taken by the written question to which he may reply in writing or by means of signs. The object of enacting the provisions of section 119 of the Evidence Act reveals that the deaf and the dumb person were earlier contemplated in a law as idiots. However, such view has subsequently been changed for the reason that modern science revealed that a person affected with such calamities are generally found more intelligent and to be susceptible to far higher culture than one was once supposed. When a deaf and dumb person is examined in the court has to exercise due cautions and take care to ascertain before he is examined that the possesses the requisite amount of intelligence and that he understands the nature of an oath. On being satisfied on this, the witness may be administered oath by appropriate means, and that also with the assistance of an interpreter. However, in a case a person can read and write, it is most desirable to adopt that method, being more satisfactory than any sign language. The law requires that there must be a record of a sign and not the interpretation of a sign. This section was amended by the Criminal Law Amendment Act 2013 on the basis of recommendations given by the Justice J.S. Verma Committee, constituted in the aftermath of December 2012 Nirbhaya rape incident. The title of this section has been changed by this amendment so as to enable the court to take resort to modalities during the course of recording of evidence as prescribed in this section, to not merely rely the dumb witnesses but to all those witnesses who are unable to communicate verbally. The effect of this section is that all such victims of a sexual offense or any other offense who are having problems communicating verbally can be witnessed, and the court can record their statement during a trial. A proviso has also been added to this section whereby the court has been obligated to take assistance of an interpreter or a special educator in a recording a statement and get the recording of such statement videographed if witness is unable to communicate verbally.